Good evening. This is John Milburn for Laws 12059 Conveyancing. We're into week 5 of 2018 term 2. Thank you, as always, for those that have joined me live for this session. And once again, I call for those of you in the unit that haven't joined us live to please do so. It provides us with an opportunity to exchange some ideas. Speaking of that, please continue to upload information, requests, questions through UCrew, and please feel free to answer any questions from fellow students. What we've discovered so far, I guess, is that there are a number of disclosures that individuals need to make. Agents, sellers, even buyers, when we're considering something like Foreign Investment Review Board. But the discussions about disclosure obligations go beyond simply nominating that certain people must disclose certain information. I say it goes beyond that because what I want you to do is adopt a mindset of thinking about the ramifications of what you read, particularly in the context of two things. Number one, providing advice to people before they sign the contract, and number two, what you would do when you're really under pressure and the clock is ticking, you're 1 hour away from settlement. So last week, as I recall, we completed what I've called case number 7. And you recall that was the problem associated with things that have come to light an hour before settlement. The removalist truck was outside and you had to make a call. And if you make the wrong call, then potentially people can lose deposits, they can lose properties, they can lose a lot of money, and it's very stressful. And often you're dealing with people that have no expectation that this problem is about to hit them. I've had situations many years ago where people were, say, buying property. We encountered problems, we tried to explain the solutions, and the reaction of the parties to the transaction was shock and dismay, disbelief. You see, the mindset typically, and this is not to belittle, but this is just my observation, the mindset of people, for example, that are buying a property is that they're more concerned about the furniture that will go in, the room colours, how they're going to decorate the lounge, how to deal with the backyard, and all those wonderful positive things. Having signed the contract, obtained the finance, and engaged you as the conveyancer to assist them in the process, they feel that everything is under control. In other words, they don't need to provide any input, you've got it under control. So when you're discussing contracts and the conveyancing process with individuals, either before they sign the contract or at the outset, I think it's important that you explain that whilst we hope and trust that everything will go well, and statistically it will, there are times where things do go badly and we need to set some ground rules. One of those is, please ensure that you are contactable at all times, and particularly the day of settlement. Things can happen very quickly, and I need your instructions, or I need at least the ability to obtain instructions. And the second, and this is something that I guess I used in explaining things to clients a bit, is it might seem as though it's a simple transaction, like you're buying a loaf of bread. I have the money. You're not going overseas during the contract. That's a big one. I have the money. You've got the bread. Let's just do a simple exchange. It's easy. People think that I've got the money, you've got the house, we just do an exchange. It's easy. But as we've seen, there's a lot more to it. And you need to warn clients about some of these potential aspects and problems. So with those things in mind, that you must consider the contract within those contexts of advice you give before the parties sign the contract and when things go wrong primarily, let's have a look at clause 7.7. I'm referring for the sake of convenience to the 14th edition. I know that's slightly outdated, but it's the 14th edition that was current when we commenced the unit, and that's what I've uploaded to Moodle. So the first thing is, I trust that everyone does have readily available their copy of the standard REOQ contract. And when I talk about the 14th edition, I'm talking about the contract for houses and residential land. So can anyone tell me what clause 7.7 is and maybe what it's all about? Any thoughts? You can feel free to unmute your microphone. No takers? All right. Property adversely affected. What does that mean? Property adversely affected. So clause 7.71 allows the buyer to terminate the contract. What do we mean by terminate? Pretty obvious, isn't it? Cancel it, call it off, bring it to an end. The contract by notice to the seller. Why is the word seller capitalised? It is capitalised, isn't it? Why is it capitalised? Rescind, yes, rescind is a good one. Definition, yes, thank you, Andrea. So when we see the word that's capitalised, it means it's definition. And it provides that if at the contract date the present use is not lawful under the relevant town planning scheme, and this has not been disclosed, the buyer may terminate the contract by notice to the seller, given on or before settlement. Let's just break that down a little bit. What do we mean by present use? Why is it capitalised? Why are those words present and use capitalised? Zoning, says Leonie, yes.
There must be a definition.
Yes, Bronwyn says there must be a definition following on what from Andrea said. Residential use, says Rachel. So can you find for me or tell me where to find the definition of present use? Where would you look? We've identified it, those words are capitalised. 1.1, says Andrea. Is it in 1.1? Let's have a look. You can see it's a little trick question here. Normally definitions are in 1.1, but it's not there, is it? So Andrea's just found that. So why is it capitalised? I thought if it was capitalised, it means it's a definition. Can anyone tell me where to find information about present use in the contract? In the Act, says Bronwyn. Maybe, but no, it's not the answer I'm looking for. In the standard contract, I'll give you a hint. In the standard contract, it's basically two parts. The first is what we call the reference schedule. Back in the old days, we used to call it the item schedule. And that goes for the first 5 pages. And then pages 6 through 14 inclusive are the terms of the contract. So it's really in two parts. And I'll give you a hint that present use is not part of the terms of the contract. So we need to look to the reference schedule. Whereabouts in the reference schedule is there present use? Now what this, page 2, thank you, Sarah. So what I'm inviting you to do through this exercise in part is to take this standard contract and know it forwards and backwards and sideways. While you're having your Wheat Bix in the morning, if that's what you have for breakfast, don't watch channel 9 or 7 or 2. Read the contract. Get to know it. If you're travelling on a train or a bus or whatever, read the contract. Get to know it, because that's always a starting point for any discussion about conveyancing. Let's go back to 7.7. So what it says is that so basically it says the buyer can terminate the contract if the present use is not lawful under the relevant town planning scheme. So we have an idea that that means we need to know something about the town planning scheme. It tells me that you must be able to access the town planning scheme and perhaps cross-reference the present use. But what is the present use? We know it's on page 2 at the bottom of the page. What if nothing is written there? What if that part is if left empty? Does that mean that there is no present use for the purposes of clause 7.7? Or do we in fact consider what is actually being undertaken on site and refer that back to the town planning scheme? Something for you to think about. What if there's a shed on the property? What if the sellers operate a business from this large shed on the property, which is really residential? May the buyers terminate? What if the buyers have no intention of operating a business on the large shed? They don't care, but they want to get out of the contract because they've decided to buy something else. Is that something you could rely upon lawfully to enable the buyers to terminate the contract? Maybe. So you need to consider some of those aspects and be prepared to provide answers. The second one is that the buyer can terminate the contract in circumstances where the land is affected by a proposal of a competent authority to alter the dimensions of any transport infrastructure. Transport infrastructure is capitalised. Where do we look? Clause 1.1 in the definition section. What does transport infrastructure mean? The meaning defined in the Transport Infrastructure Act 1994. So you need to have that act handy as part of your toolkit in giving advice. And only if the competent authority, if the land is affected by a proposal, under the terms of that legislation, may the buyer terminate the contract. Not a lot of answers. I'm not giving you a lot of answers just yet, but you can see what I'm encouraging you to do, and that is to read the contract thoughtfully and have access to information that you might need, in a hurry, like in a take-home exam type context. It's not necessarily a hint, but you know what I mean. The buyer may terminate the contract if at the contract date access or any service to the land passes unlawfully through other land. We're really talking about an easement type here, aren't we? What if the easement is not registered? And what if it's a statutory easement? I guess that probably is a statutory easement. So you need to consider that. Those of you that are doing land law, you might have an advantage in that we'll be talking about easements in land law. A competent authority, this is number 4. Don't worry, I'm not going to go through them all, but a competent authority has issued a notice to treat or notice to intend to resume, a notice of intention to resume part of the land. Well, what if the council has not gone too far? Refer to this case, Zekos, now it's a silent T, T-S-E-K-O-S, against Finance Corporation of Australia, 1982, 2 New South Wales Law Reports, NSWLR 347. In that case, the seller was aware that a local authority intended to resume 3 properties, even engaged in some correspondence. The buyers were still not able to determine the contract and claim damages. And in fact, to add insult, the court found the buyers had wrongfully repudiated the contract, were therefore in breach, and the court held that the intention of the council, which had not yet manifested itself in a notice to treat or notice to resume, was not a defect in title, and the buyers were ordered to proceed and pay court costs. So you need to be careful about the advice that you give. Clause 7.72 says, if notice is given, the buyer is treated as accepting the property, and if no notice is given, the buyer is treated as accepting the property, and 7.73 provides the authority for the buyer to inspect the records held by an authority. So that gives you the authority to have a look at those records, which might otherwise be subject to privacy laws. All right, so have a look at 7.7 interesting clause and one that you need to be aware of the ramifications if attempting to exercise it. Now, we've been talking about disclosure obligations, which in a sense requires consideration about things that were said, but also things that were not said. So in terms of silence and obligations, there are issues to do with contract law, issues to do with the general law, caveat emptor, but also consumer legislation. Have a look at this case. It's Dormer, D-O-R-M-E-R, against Solo Investments, Pty Ltd, 1974 1 New South Wales Law Reports 428, and you'll see this in Land Contracts in Queensland at page, I think, 85. Holland J said in that case, it seems to me that the general rule about the general rule in contracts of sale and purchase is still undoubtedly caveat emptor. So the general rule is still let the buyer beware. So accordingly, under the general law, at the date of entering into the contract, matters which might give rise to the possibility of future adverse effects on the property are not required to be disclosed. Sellers don't have to disclose that. But legislation has changed that, and obligations are imposed on sellers beyond the common law because there are certain provisions which enable consumers to have protection. Obviously, there's the Australian consumer law. You might need to consider that in the context of any allegation of consumer protection. But another few pieces of legislation. I'll give you three. There are more than this. I'm just giving you some examples. And this is where you need to be aware of other external pieces of legislation. The first, and I think this is in the notes, I think all three of them are in the notes, the Queensland Building and Construction Commission Act of 1991. Refer to section 47 of the QBCC Act. It relates to building works performed on a property where performed by an unlicensed builder, sold within 6 years of completion, the seller is required to give the buyer a contract, before contract, a prescribed notice detailing the building work carried out, and the notice alerts the buyer that work is not covered by the insurance. And Rachel says, so how does the ACL really work? It's a fairly complicated answer. You'd think it would be a simple answer, but all I'll do at this stage is just flag it as something you should consider. But really, the key is that it relates to consumers, but only in certain circumstances. So not every contract will necessarily deal with yes, Sarah says it helps to govern the actions of agents because you've got a commercial aspect to it. So, but not every buyer and seller. And there are issues to do with misleading and deceptive conduct, particularly for agents, yes. Right, so the QBCC Act says if you've got an unlicensed builder and it's still within 6 years, you're selling the property, you need to give notice. So if you're acting in a conveyance, let's say a question, and the contracts provide simply that someone is selling the property, it's 4 years old, and then I go on to ask another question, you've got to remember to think, okay, that's less than 6 years. I must at least refer to the QBCCA in my answer, even if it means I'm making an assumption. So you could say, I'm assuming that the property was built by a licensed person. Otherwise, section 47 of the QBCCA may apply in these circumstances. Environmental Protection Act 1994, section 408, provides that an owner of land where it's recorded on the Environmental Management Register or Contaminated Land Register must provide an indication about show cause notices or evaluations or clean-up notices. So does anyone know about the Contaminated Land Register? what it means, how you might search it? It's a loaded question, looking at the conveyances again. Contaminated land register. What's all that about? All right, so you can undertake a search of the contaminated land register, which will identify certain environmental issues that might be relevant to the property. And it's something that would normally be done as part of prudent conveyancing. Now, I know I'm moving around in different areas, but does anyone know what a put and call option agreement is? Anyone heard of that? Put and call option? If you have, I'll give you an opportunity to explain it to me. Does anyone know what an option is? An option to purchase?
It's where you put a small consideration down and you get an option for, say, 3 months or a certain term to do some due diligence on the property before you actually go ahead and sign the contract. And that's with a call option. And then if there's a put and call option, it's kind of, the call option gives, I think, the purchaser the right to call up the option, and the put option is the seller. If the purchaser doesn't want to proceed with the contract, the seller has the right to enforce the contract, put the contract in place and ask the buyer to proceed. Something
Excellent.
like that.
Excellent. That's spot on. That's very, very good. All right. Leonie says first rights. It's a little different to first rights. I'll just explain this. I know I'm digressing a little bit, but Bronwyn is right. So a call option enables a buyer to call upon the seller to sell the property. A put option enables a seller to put the property to the buyer and say, you've got to buy it. I'm making the call. So a put and call option, or a put and call agreement, is where both parties have the ability to force the other to proceed. They don't have to, but both parties have the ability to do it. That's a put and call option agreement. And Bronwyn's right. Usually there's some money change hands. So typically when we talk about an option, we're talking about a call option in favour of a buyer to purchase a property if they give notice of their intent to do so. So let's say you had $1 million property and you wanted to do your due diligence, have 3 months to think about it, get everything organised before you make the call that you're going to buy it. You might make an offer to enter into an option agreement, and in that option agreement you might say, I will pay you $1,000, and in consideration of that, I now have the right to buy that property at any time I give notice to do so within the next 3 months on these terms. And what you'd normally do is attach as an annexure the actual contract that will be signed if you exercise your rights under the option. That's a call option. Put option is in reverse. A little different to a right of first refusal or preemptive right, which means that if you have the right of first refusal, you can't actually call upon the seller to sell the property to you. However, you are entitled to receive the first opportunity to buy it on certain terms if the seller decides to sell during a period of time. We see that often in leases. I hope that's a quick little intro, but I hope that makes some sense. Any questions about put call options or preemptive rights or / rights of first refusal? Preemptive right is what I call a right of first refusal. All good? Easy? Okay. Just bear in mind that there are stamp duty implications on all of these things, or transfer duty implications. Have a look at a case. It's APM Property number 3, Pty Ltd against Blondeau, BLONDEAU, 2009 Queensland Supreme Court, QSC 326. Justice Mullins determined that in the context of a put and call option, having regard to the protective purpose of the legislation, if part of the land sold was included or recorded on the Environmental Management Register, then the buyers could validly terminate the agreement. Likewise, in Interse, INTERESSE properties against LJ and BJ Investments, 2010 QSC 325, Justice Wilson determined that the true nature of put and call deeds really did constitute an agreement to dispose of land. Okay, so that's a little digression. Let's just come back to some of the other pieces of legislation that may have a bearing on disclosure obligations. There is the Coastal Protection and Management Act, 1995. If there is an undischarged coastal protection notice, seller must give buyer written notice of the undischarged notice not less than 14 days before settlement. And there is the disclosure under obligations under the contract that the seller is the registered owner of land at settlement. This is an interesting case. See what you think. It's Rolls and Radford. It's in the material. And in that, it says that two people were noted on the contract as sellers. The lot sold was one of two lots created by the sellers. So the two sellers were on the title and they basically made two lots out of the one lot. So they were both registered on both titles. But what in the reality is that they had actually decided that one of them would take one, the other would take the other. The two people are on the contract. The buyer's solicitors purported to terminate on the basis that the two people that were on the contract was not the one person who was on the title as at date of settlement. Justice Philippides took a very black letter law approach to this by saying that the terms of the contract were clear, they were unambiguous, and that is the buyer was entitled to terminate the contract in those circumstances because the contract provided that the seller would be the registered owner of the freehold at settlement. We're all doing okay? Hanging in there? Any questions, comments? All good? All right, we'll just move on to the Body Corporate and Community Management Act, 1997. The primary object here is to provide for flexible and contemporary communal-based arrangements for the use of freehold land. And in the QBC, the BCCM, the Act provides for the establishment of community title schemes and the operation and management of community title schemes. We used to call them body corporate, we used to call them strata title and body corporate schemes, but now they're just basically community title schemes. Have a look at section 10 of that Act for the definition of a community title scheme, and think about and become aware of community title scheme development. So when a property is developed into a community title scheme, there will be a number, might be 2, it might be 200 individual lots created, but there's every likelihood there'll also be common property. And this will be all governed by the community title scheme development. And there's a standard format, the standard format plan, which is really for very simple little lots. There's the building format plan and there's the volumetric format plan. So have a look at that in the legislation. I won't dwell on that, but just be aware of it. Also, in the context of conveyancing and disclosure obligations, the BCCM imposes disclosure obligations on a seller of a lot in a proposed lot of a community title scheme. We've talked about the Land Sales Act, so it's a bit like that. So for off-the-plan sales of lots in a community title scheme, there are disclosure obligations on a developer, seller, as there are for flat land subdivisions, is the term that I use. So these substantially provide obligations of disclosure in relation to body corporate. Just going to pose this to you, see what you think. If you were the developer of a property, let's say a unit block, would you rather sell the property on the basis that the body corporate fees are high, relatively high, or relatively low? It's not really a trick question. Low, says Rachel. High, says Leonie. Sarah says high. So we're getting a different vote. Now, does anyone want to volunteer why it would be? Okay, so Sarah's getting to what I'm after now. Sarah says, better to be high. It will cover more under the sinking and administrative fund levy. Sarah, did you want to elaborate on that and explain what we mean by the sinking fund and the administrative fund levies?
Yeah, I'll try to.
Okay.
So with the sinking and admin fund levies, obviously each owner of a body corporate property will be liable to pay it. It's apportioned depending on how many lots there are, so not everyone might be equal. Some may pay more than others, depending on the size of your lot. The beauty of having a higher lot is if something happens to the building, like for instance a property in Gladstone, where the units have a huge crack across the foundation of the back of the units, they have enough money in the funds to fix it. If they don't have money in the funds, then obviously they start come knocking on the owner's doors wanting payment so they can fix the issues.
Very good. Okay, so Sarah's put forward a good argument as to why the fund should be high. Now, Rachel, can I put you in the spot? Why do you think, from a developer's perspective, it would be better for the fund, the levels to be set low?
Because they're ongoing costs that essentially get added to rates. I mean, obviously, people want their rates and ongoing costs to be as low as possible. I had a friend who had bought something in a community title, and I think her body corporate fees were something like $9,000, and it was added to rates. So it's pretty substantial. And even though it's nice to have this big bucket of money, in her case, they were spending it on gardening and all sorts of things, and they weren't actually holding on to the money. They were spending it on beautification, which I guess would sort of maybe raise it in the long term, but it was also getting more and more difficult to sort of pay those fees over time.
Okay, thank you, Rachel, for putting forward that contrary view. I guess from a developer's perspective, there might be a couple of aspects. I agree with everyone that everything you've all said. There's no necessarily right or wrong answer. But from a developer's perspective, if there are, let's say, 100 lots in the development, and at the time of the release of the lots, the settlement, if you like, there has been a sale of 60, it means the developer's stuck, at least for a while, with 40. And the developer might say to you, please don't, I don't want this high, because I'm going to be paying for almost half of it for the first year or so. Maybe then they can be increased when I'm out of it. And also, I'd rather them low because I'm going to attract more buyers. You know, buyer beware. They should be aware that if they come in and the body corporate fees are low at the start, well, odds are, as Sarah pointed out, there may be a catch-up down the track, but that's not my problem. So you can see that there might be competing interests here. What does that tell you? And I'm really thinking about what Sarah contributed. As an advisor to someone going into a unit development, high-rise, let's say, that is aged, let's say it's 10 or 15 years old, 20 years old, before they sign the contract, what advice would you give them in relation to the issues of sinking fund and administrative levy? Any thoughts? Okay, Bronwyn says, do a full body corporate records inspection Sarah says, do a search of the body corporate records. And what do we mean by a full body corporate record inspection? In other words, can you do an abbreviated search of body corporate records as opposed to a full search of body corporate records? And why? And how much would it cost and how much time does it take?
A full body corporate records search gives you all the minutes of the meetings and all the records of the historical records of the body corporate, and it allows the buyer to see whether there's any special levies that have been issued and whether they're going to cop extra additional fees in the future. And then it's up to them to review it and make a decision as to whether they want to proceed knowing that information. And you can get a small search of the body corp records, just like in your standard searches, a body corporate inspection, which just gives you the current levies, but it doesn't tell you all that history. But if it's an older building, you definitely recommend to get that. And the ones we get are about $330.
And I would have thought that's quite good value, actually, $330. I thought they were more expensive than that. But yeah, so that's great. Thank you, Bronwyn. Really appreciate that. So you can obtain a basic search, which will give you information about the current levies and whether they're paid and a few other things, body corporate lot entitlements, for example, but not a lot of the history. So what Bronwyn suggests is that you might do a full body corporate inspection, which means looking at the minutes. You think, well, how boring would that be? Well, it wouldn't be boring if you came across a minute from 6 months ago that said that engineers have inspected the building and determined that there is a real prospect of concrete fatigue, and the body corporate needs to be aware that the building could be up for substantial repairs and modifications costing $300,000. If you compare that with how much is in the sinking fund being the fund that deals with long-term proposed expenditure, and you see there's only $40,000 in the sinking fund, it won't take you long to realise that if you buy this building, odds are you're going to be the subject of a special levy and called upon to contribute to make up the shortfall between what's in the sinking fund and what is needed by the body corporate to remedy this long-term structural problem. So inspecting the records are really important, I think, in terms of an older building particularly. Which comes back to the earlier point, and that is in setting the body corporate and administrative fees from the outset, what is your aim? There's no right or wrong answer here. Are you aiming to keep it low, which might mean it's more potentially attractive to sell the building? Or are you going to keep them high so that everyone has the comfort of knowing that you'll be covered down the track? It's a weighing up thing, but as a buyer, you need to be aware of that. As an advisor, you need to be able to explain that to the clients. Another advantage of checking the body corporate minutes, I think, is that you never know what else you might find. There might be complaints over Christmas that for a period of 3 months, one of the owners has his death metal band come in and do practice sessions in unit number 201. So maybe 202 and 203 are on the market because they don't want to go through another summer of death metal up against their walls. I don't know, it's just a silly example, but it is important that you look at this information. All right, anything else on, now admin levies relate to the day-to-day expenditure. So the mowing, looking after the swimming pool, those sorts of things. Sinking fund is for long-term expenditure. All good? Okay. Now there are some termination rights for a proposed community title scheme. Have a look at sections 217 and 218 in the context of the buyer's ability to withdraw from a contract in circumstances where the contract of sale or the disclosure obligations for the contract of sale have not come to fruition. The key point is this, that in order for a buyer to terminate, the buyer must be able to establish that there has been a material prejudice if compelled to complete the contract. In that regard, look at sections 217 and 217A. So the question is, would the buyer be materially prejudiced if compelled to complete the contract? There is a case, Margaret Wilson J. Considered that question in Wilson against Mirvac, Queensland, 2010 QSC 87. And in that case, paragraphs 22 and 32 are relevant. I'll read them briefly. 22. In construing the Act, the interpretation which best achieves the objects are those preferred to other acts are consumer protection provisions. As such, they should be construed beneficially, resolving ambiguity in favour of the consumer. 32. Some matters are clear. The focus is on the buyer. That suggests the test is objective. B, given the buyer only has 14 days in which to cancel the contract and the completion may be many months away, material prejudice must be assessed in light of the buyer's circumstances when the further statement is received. This is to do with a variation. And there must be a causal relationship between inaccuracy and prejudice. So what I'm really saying is that where there is an off-the-plan contract, the disclosure obligation is important. Part of that is an obligation on the developer to disclose any changes that may occur and give notice of those changes. And sections 217 and 218 relate to the buyer's ability to terminate the contract in circumstances where there are changes. Then the buyer would need to say that they've been materially prejudiced as a result of that change in order to proceed or be forced to proceed. The last case example we did was case 6, I think, which means that we're ready for case number 7. So we're in the 22, means you've got to concentrate hard now, and it's only quick, so it won't take you long. ABC entered into an off-the-plan contract to purchase industrial land on the 30th of June 2017. The company intends to build its main depot on the site. The contract was unconditional as to finance. Your client comes to you and advises that another property has come onto the market. It's far more suitable and at a cheaper price. Can your client, ABC, terminate the original contract? And what strategies would you consider available to it in that regard? It's off the plan contract. Finances, it's unconditional as to finance. Can the buyer terminate? If so, what are the strategies? What are the things you'd need to look at? Okay, Sarah says, when was it due to register? They may be able to terminate under a sunset date. That's actually the first thing I thought of as well. I think that's really important. Is there any other way that they could terminate the contract? And it's a broad question. There's no right or wrong answer to this. The size of the land being varied and them being materially prejudiced. Yes, that might be it. There might be something in the disclosure statements that you can look at. I would literally go through the item schedule or the reference schedule and the terms of the contract, almost clause by clause, to say, is there something in this clause, in this part of the document, that would give my client an out? Beyond that, after I've gone through the contract, I'd look at the BCCM provisions and the off-the-plan provisions. I'd ask whether there have been any variations, whether the disclosure is consistent. I'd consider the sunset provisions of the contract, and then you'd consider any searches that you've undertaken generally. I'd consider whether the seller is the same as that which will be on the title. We talked about a case earlier tonight where there was a discrepancy between the two. So it's almost as if you've got a checklist here of things that you would look at if your client wants you to terminate the contract. Sarah says, was the disclosure provided before the contract was signed? So yes, the timing may be relevant, and it might just be that the documents are on the same day, but maybe they are provided or signed in the wrong order. So there are a few things that you need to consider. So that's case number 7. And that should just about do us for tonight. We are, in fact, 1 week behind. This week I should have been dealing with issues to do with formation of contract. We will catch up, but not next week, because next week is our break week. So we'll be seeing you again in 2 weeks' time. Are there any questions, comments, anything you want to discuss? Or are we all good? All under control? Okay. Thank you very much for attending tonight. Those of you watching this as a recorded session, please consider attending live, and we'll see you all in 2 weeks. Bye for now.